The area of law and neuroscience that I've focused on for some years, not exclusively, but significantly, is the intersection of pain and law. And at first we might think, why pain and law? And I hope to convince you by the end of the hour that that's a logical and important intersection that shows us both how neuroscience and brain imaging specifically can add valuable and important information to legal discourse, yet also how fundamentally normative questions resist factual and scientific solutions and may in fact merely use advances in neuroscience in instrumental ways to support pre-existing normative commitments rather than advancing the substantive question. In the past, and when Martha's heard other versions of this talk, I've spoken the most about chronic pain in disability law and to some extent in drug regulation. But because of the recent decision in Dobbs versus Jackson Women's Health, I'm going to put a little bit more of an emphasis in this talk on the discourse around the neuroscience of pain in fetuses. And with that, let me share my screen and we can start getting to some of the slides. So why does pain come up in the law? If you're not a lawyer, or even if you are, you've probably not thought of pain and law together. And again, I apologize for the slides being so chunky instead of line by line. The first is that much of our legal system is designed around claims for redress, that particularly the civil legal system, tort law, and some regulatory law is available to people when they are harmed or injured. And often harms and injuries involve various kinds of pain, including financial, physical, psychological, moral, and dignitary, because pain can mean a lot of things. I'm principally going to focus on physical and psychological pain. Second, the legal system works to establish rights as well as limitations, what rights we have from our government and what limitations we place upon our government. And this can involve cabining the power of the state relative to the body. How much pain can the state lawfully inflict? When does the state have a duty to step in to prevent pain? Both of these arise when we're talking about constitutional issues. The Eighth Amendment limits cruel and unusual punishment. How much pain in punishment is considered cruel? And is that a moving target? Whether the state can step in and limit our rights based on pain is a relatively new discourse, and it comes up squarely in Dobbs. As we'll see, the Supreme Court said for the first time that the state has a compelling interest in preventing fetal pain. Pain, of course, also presents central ethical considerations. When is pain wrong? We might have a gut sense that pain is bad. Pain is certainly aversive. But when is it wrong? I'd suggest that pain, the extent to which pain is valued in the legal system and whose pain counts, tells us a great deal about who is a rights-bearing being and whose rights count more. When is pain credited? When is pain denied? When is there redress for pain or not? And all of these questions have physical components, but are fundamentally normative. So specifically in terms of doctrine, I already mentioned the constitutional dimension. Pain features in international norms and treaties. There are conventions on the rights of prisoners, conventions against torture, and in these, rights are principally defined in terms of a right to be free from excess pain, and conduct is considered torturous largely based on how much pain it causes. But how much pain constitutes torture? It really depends on how permissive or not a regime wants to be toward torture. I think I can see raised hands on this screen. Raise your hand if you've heard of the Bybee or Beebe memo, John Beebe, also John Yoo. No, yeah. All right, so I appreciate that. I'll presume no knowledge. So during the second Bush administration, there was a memorandum promulgated about the interrogation of prisoners in Iraq and Afghanistan that first stated the intention of the United States to comply fully with all international treaties to which the United States is party, but then providing its own definition of what constitutes torture, defining torture as conduct that causes pain equivalent to conduct that causes permanent organ failure or death, permanent disfigurement, or an amount of pain equal to organ failure or death. On the one hand, this sounds like a gruesomely high standard. On the other hand, if we think about it as medical thinkers, it's also a really non-workable standard, because organ failure and death could be painless. I could die in my sleep of heart failure and never know anything about it. So we think that this gives us a standard, but it's really a non-standard. It's a standard that just says, we think we ought to be able to cause a lot of pain, but we're not going to think carefully about how much pain is too much. We're just going to set a high ceiling, but a high ceiling that can't really be tested. You know, I couldn't, if I had a perfect pain measurement machine, I wouldn't be able to hook somebody up to it and tell you whether they were experiencing pain equal to organ failure and death, because how much pain is that? It's really undefined. So that memorandum is a good example of the ways in which medical language relating to pain can be deceptive and can be used to tell us who we value and how much we value. Criminal law echoes this, because domestic criminal law has special penalties for people who inflict greater pain on their victims. In states that have capital punishment, an intentional and premeditated killing may or may not be eligible for capital punishment. Typically, what will push it over the threshold into being a death penalty eligible killing is if the killer inflicted what's called heinous, atrocious, and cruel conduct upon the victim, which is also described in terms of excess pain. And that additional pain that the victim suffers is deemed to be more morally reprehensible on the part of the killer, and therefore makes that killer death eligible. So that tells us, on the one hand, how important we view pain to be if it is a so-called innocent victim, but the same level of pain may be acceptable if we view the person as not an innocent victim, potentially a terrorist who needs to be interrogated. So these prohibitions against pain, or extra penalties for pain, are defined in terms of pain, but their relevance arises out of who is the subject of the pain. Is it the innocent victim who the law is trying to protect, or is it the individual who is suspect, who we might view as an enemy? Then their pain at an equal level may or may not count. Then, in a different vein, administrative and civil law, tort law, have a lot to do with pain. So disability law and workers' compensation, a person may be eligible depending on the amount of pain they suffer. Similarly, ERISA law, that's insurance law, and tort law. You've all heard probably of pain and suffering damages. So we might think with disability and tort law that we want to be able to quantify pain. How much pain is a person in, and where does their pain come from, such that they could be eligible for compensation. But those regimes have a pretty problematic relationship to pain and pain biology as well, again, based on certain normative dimensions about whose claims are likely to be valid or not, whose claims do we doubt or not. But I think the main thing that we can take away from this slide is that from international law down to constitutional law, from criminal law down to civil and administrative law, pain is everywhere in the law. And how does pain relate to neuroscience and law? Well, what is pain? All pain comes from the brain. There's an old joke. It's not a very good joke, so excuse me for telling you guys a bad joke. A neuroscientist is involved in a car accident, and they're rushed to the emergency room with multiple injuries. And the first provider who rushes to their side says, "Where does it hurt? Where does it hurt?" And the neuroscientist says, "In my brain, obviously." Because no matter where the injury is, pain requires central processing. So before we get into pain, I want to separate pain versus nociception. And if we had animations going, we'd see some nice movement on this slide. Other than Martha, please raise your hand if you have heard of nociception before. I do more of this hand raising these days because I've been teaching for so long and my students have such different backgrounds. Okay, so a fair number. I see 4 hands right now, 5 hands. So I will lightly describe the difference between, actually, does anybody want to jump in? Anybody who's raised their hand and tell us what nociception is, so it's not just me talking at you? And then all the hands disappear and silence, of course, yeah. So I think even from elementary school biology, we're familiar with something like what you see on this slide here. There is some aversive or noxious or harmful stimulus, here represented by a candle flame, that stimulates an afferent neuron, a neuron that goes from the periphery up to the central nervous system. And that transmits a signal, these 3 dots would animate for us, along the axon of the neuron, past the cell body, and then to a presynaptic terminal. Then there's a little interneuron here that connects this to the spinal cord. And then from there, this arrow upward represents upward transmission to the brain. The brain would interpret this signal. It would say something like ouch and hot and anything else relevant. And then an efferent, then a signal would go back down, and an efferent neuron would probably result in the hand being jerked away from the flame. So this is how the body is able to detect and respond to aversive stimuli. Why do I say aversive but not painful? Well, here's a little more on nociception, that when we get to this, these spaces here with the interneurons and upward transmission to the brain, many factors can affect the extent to which this signal is transmitted up, and then the way the brain could make sense of the signal. A person's physiological state or an organism's physiological state, whether, for example, it has opiates in the system or whether it has a sufficient amount of glutamate, affect the rapidity and intensity of that transmission. And so there can be amplification or dampening of a nociceptive signal before transmission to the brain. When it gets to the brain, we may have pain if the subject is conscious, because nociception, so far, nothing has happened that requires conscious experience. It's all really quite mechanical, and chemical and electrical. But what it is not yet is experiential or interpretive. So nociception occurs without conscious experience. And if the subject isn't conscious, the stimuli are still detected. There's still a physiological response, but it doesn't hurt. Even though it doesn't hurt, it can still be relevant. So, for example, we say it is believed that fetuses early in gestation don't experience pain, that they don't have the thalamocortical structures, as well as the consciousness, the awakeness to experience pain. But anesthesia still may be administered, should be administered frequently in fetal surgery, because nociception can cause spikes in cortisol, which can then affect heart rate and wound healing and diverse other processes. Same thing with an unconscious patient. Nociception will still affect their physiology in numerous ways. So it's not that nociception doesn't matter, it's that it is different from or distinct from pain. So what is pain? Pain, according to the International Association for the Study of Pain, this lightly revised definition from 2020, is described as an unpleasant sensory and emotional experience associated with or resembling that associated with actual or potential tissue damage. Often, nociception and pain are closely coupled, and I'll get to the next slide in a minute, but they need not be. So acute pain is sudden in onset. There's an initial stimulus, usually an external nociceptive stimulus, not always. And then with a conscious subject, there is pain processing and the subjective experience of pain. But not all, just as not all nociception leads to pain, not all pain comes from nociception. So let's take a look at different types of pain. And that's relevant to thinking about disability and tort, somewhat less to the fetal pain example that we'll talk about in a little while. So pain is often grouped into two different kinds, roughly. Acute pain, sudden in onset, usually rapid in resolution. And there's almost always some external or internal nociceptive input. Even by internal nociceptive input, I mean something like a muscle cramp. An external nociceptive input, you step on a splinter. Chronic pain is defined by the IASP and many pain scientists as simply as pain that endures for 6 months or longer. And it may or may not be associated with nociceptive input. Some clinicians and pain scientists prefer to group pain somewhat differently. Instead of acute versus chronic, they look at nociceptive versus pathological pain. So nociceptive pain resulting from nociceptive input, regardless of duration. So if I had a splinter in my foot for 6 months and it still hurt after 6 months, that would not be, on this definition, chronic or pathological pain. It would be just ongoing nociceptive input. And then different from pain closely linked to nociceptive input, pathological pain, which is said to result from disorders in the central nervous system, interpretation of pain signaling. So I could have a pain disorder where I experience a burning sensation in my face, but there is no stimulus that is causing a burn. And this is why, to go back to the IASP definition, an unpleasant sensory and emotional experience associated with or resembling that associated with actual or potential tissue damage. When I have my burning pain from my neuropathic pain syndrome, it is like being burned. So it resembles that associated with actual or potential tissue damage, but there is no actual tissue damage there at the site where I feel the burning. Although, is there potentially tissue damage somewhere else, potentially neurologically? This definition of pain and the fact that there can be pain maintained without nociceptive input is of particular relevance in the disability arena, because many chronic pain disorders involve pathological pain, where a person may have experienced an acute injury and nociceptive pain, but then the pain chronifies and involves central sensitization, central remodeling, and then the pain may be sustained even in the absence of an ongoing injury, but that is not recognized in disability law. Pain has presented these sort of mysterious qualities for a long time, because as real as it is frequently, well, it is invisible. Even if we can see an injury, we can't see the pain that goes with it. So one of the first areas that functional magnetic resonance imaging was used to image was the brain in pain. Is there such a thing as a consistent pain signature, for example? And is there a pain area? Is there a reliable way of telling how much pain somebody is in and measuring pain using neuroimaging? Like most good scientific research questions, looking at the brain in pain has led to more questions than answers, although it has led to certainly some important findings. One of the things we can see on this slide is the the huge diversity and range of brain areas that become active during processing a painful experience. Certainly, there's activity in the spinal cord and the thalamus, which is very much the gateway to the brain. Then activity in the somatosensory cortices correlating to the areas in which the painful stimuli are being experienced. There's almost always some activity in the insula. And then anterior cingulate cortex is variable and prefrontal cortex is variable. There is also activity observed in the amygdala, hippocampus, posterior parietal cortex, basal ganglia, and brainstem. And this is in controlled lab experiments with healthy subjects who are given a single type of painful stimulus. For example, a thermal stimulus would be typical, either hot or cold. So this diversity of areas being activated is not representative of people with diverse medical conditions or numerous kinds of stimuli that are different from each other, either in location or type. Instead, we see these numerous forms of activation across consistent stimuli. So this tells us what conscious pain, how many functions are involved in conscious pain processing. That said, there are still consistent enough signals across subjects that on average, fMRI can be a reasonably good pain detector for acute nociceptive pain in healthy subjects with no incentive to deceive in the lab, using pattern classification programs with enough subjects who receive the same kind of painful stimulus, and who again are all basically right-handed healthy subjects. We can then infer, make a reverse inference from a scan whether or not a subject was receiving the painful stimulus or a control stimulus. So there is some way to use fMRI to discern pain. And increasingly, and this is not within the scope of my review, but I need to get smarter on this, it appears to be possible to use FNIRS, functional near infrared imaging, on anesthetized subjects undergoing surgery to determine if they are experiencing pain. So that could have some interesting clinical applications. But with chronic pain, the signals are much, much less clear, except we can see with some structural imaging, I'm going to go relatively quickly through this, with some structural imaging that there are volumetric changes in the brains of people who have chronic pain disorders. So as you probably already know, apologies for being too basic, if we're looking at an MRI in 3 dimensions, that just as a 2-dimensional picture is composed of pixels, a 3-dimensional picture is composed of voxels or volumetric pixels. And if we compare the volume of brain regions in people with specific chronic pain disorders relative to controls, we see volumetric reduction. It's not clear if it's atrophy or actual neuronal death, or if there is recovery with treatment in people with chronic pain disorders, that there is about 27% of subjects with chronic pain disorders experience some volumetric decrease in the frontal lobe, particularly in the frontal cortex, prefrontal cortex, and dorsolateral prefrontal cortex. And about 23% of subjects with chronic pain experience some volumetric loss in the cingulate cortex. So this and these areas of loss may vary to some extent depending on the conditions. So chronic back pain, there's more volumetric loss in the DLPFC, and with fibromyalgia, there's more volumetric loss in the cingulate cortex and the medial frontal cortex. So I'm going to stop sharing for just a minute and talk about that a little. So in the IASP definition that talked about pain being associated with or experienced in terms of tissue damage, this may interestingly disaggregate these 2 concepts of the experience of pain being like tissue damage and where the tissue damage may be. So I may experience a burning pain in my face, and it's associated, it is experienced in terms of what feels like tissue damage here. But in fact, the tissue damage may be in an area where, of course, I can't feel it. We don't feel what goes on in our brain. So it may be that pain that is experienced as being like tissue damage, but without observable tissue damage, the tissue damage is simply elsewhere, or not so simply. This matters very much in terms of Social Security determinations. And Martha, I apologize because you've certainly heard me talk about this before, but the law hasn't changed yet, so I'm going to keep talking about it. And then I'll talk a little bit about where it has changed in a way that I find hopeful. The Social Security Disability Administration provides compensation to people who experience illness or injury or other medical condition expected to last 6 months or longer that interferes with employment and major life activities. So how does it deal with pain? The short answer is it mostly doesn't. About 65% of claims for disability involve pain, but ones where pain is the primary complaint, most of them are denied. And of the 600,000 appeals of denials that the Social Security Administration hears per year, pain figures largely in all of them, or almost all of them. So why is pain such a big deal there? It's because the disability system compensates people or provides recognition for all diagnoses except primary pain disorders. Pain in disability is supposed to be associated with overt tissue damage, and tissue damage that is sufficient to cause the ongoing pain. In other words, it recognizes nociceptive pain. So if I'm in an industrial accident and my pelvis is crushed, God forbid, and then it's put together with all kinds of wire pins, and those pins impinge on me in such a way as to cause pain, that is pain associated with tissue damage. On the other hand, if I have an industrial accident and I develop a complex regional pain disorder, a pain processing problem that can be diagnosed, and there are objective tests for it, but my overt injuries heal, my bones look fine on X-ray at this point, that is considered quote unquote excess pain, because there is no nociceptive, ongoing nociceptive input, no direct correlation to tissue damage. That pain is considered basically not real, and it's not considered as a basis for compensation. The only way a person can obtain compensation for their excess pain is if the pain is diagnosed as functional or a part of a somatoform disorder, which is the polite modern term for a conversion disorder. And who knows the history of a conversion disorder, or what conversion disorder would have been called 100 years ago? There must be someone. No? You're all
hysteria?
Yes, hysteria. Hysteria came to be seen as rude. So it was called conversion disorder, the conversion of psychiatric symptoms or emotional symptoms into physical distress. Then conversion disorder came to be considered rude, so it was renamed somatoform pain disorder. Somatoform rather than somatic. So if I have a primary pain disorder that seems out of proportion to my tissue damage, then I could get a psychiatrist to diagnose me with effectively hysteria, and then I could get compensation for disability on the grounds that I'm psychiatrically disabled. So I think one of the great forms of potential in brain imaging is to show that there is actually tissue damage in chronic pain disorders. It's just that the tissue damage is in the brain. And to show, and now there's 25, 30 years of really good science showing this, that chronic pain disorders are real. They can be exacerbated by psychiatric conditions. It may be that people who have a predisposition to psychiatric conditions may also be more vulnerable to chronic pain conditions, a kind of diathesis or shared genetic predisposition, but that they're not the same. Nor should people in pain be treated as merely psychiatrically ill, although of course psychiatric disabilities are perfectly real too, as well as neurological. So, you know, why are we still drawing these mind-body lines when the mind is in the body and the body helps enable and create the mind? So this has not, as I said, you know, spoiler alert, this hasn't transformed Social Security law yet, but it is starting to change the way courts of appeal look at denials of disability, and it's starting to change the way expert testimony is used in tort cases where people have chronic pain following an injury. Brain imaging can't show reliably whether one person or another is in chronic pain, but it can show that pain conditions exist. And so, you know, to the neophyte juror, or even to the well-intentioned Social Security administrative law judge who isn't an expert in chronic pain, it may seem hard to understand or even fanciful that a person with no injury could be in horrific pain, feel like they're burning up. And so having experts come in to give background evidence, what's sometimes called framework evidence, about the neurological reality of pain. How is pain processed? How does chronic pain, pathological pain come to exist following an injury? How can pain be apparently disproportionate to the injury? Is tremendously valuable, and it debiases people and changes their preconceptions, because since we all have experienced some pain in our lives, we may have the misleading sense that we're experts in it. I know what pain is. I've had pain. How could they have that kind of pain? Just like jurors and policymakers for a long time had a misleading belief that they understood how crime victims would act. It used to be believed that anybody who was the victim of a serious crime, and especially something as heinous as sexual abuse or rape, would of course report it promptly. But then it turns out that many victims, especially child victims, don't report promptly. And we needed sociologists and psychologists to do years of empirical research. Now we have a changed presumption that delayed reporting is considered normal or understandable. Similarly, there used to be a view that eyewitness testimony was just about infallible. Then we've had years of great science on memory and perception, and now we know that memory, especially memory under stress, can be particularly subject to distortion. So just as a memory expert cannot come into court and tell jurors whether this witness did or didn't see someone, a pain expert can't come into court and tell the jury whether a brain scan proves that this person is or isn't in pain. But like the same memory expert, what the expert witness can do is explain the neurobiology of chronic pain, how it comes to exist, and give them that framework for making a better judgment. Now, moving on from chronic pain and tort and disability, let's look at how, which is part of this section, can understanding and detecting pain improve outcomes in any legal arena? Well, the short answer, I think it can. And hearteningly, the Veterans Administration has recognized the reality of chronic pain and has referenced neuroimaging studies sorry, I'm getting some feedback, to overturn the denial of benefits to veterans who have chronic pain syndromes following the resolution of their in-service injuries. But whenever we're talking about pain in law, in fact, many biological concepts in law, it's important to keep in mind both the factual and the normative. And these normative and factual dimensions come together, particularly in discourses around abortion, solitary confinement, disability and tort. And then I'm not going to have a chance, which I've already talked about, and then I'm not going to have a chance to talk about this last one, access to pain medication and restrictions on opioids. But that's a really interesting area of kind of over-enforcement in the legal system. Kind of, you all know the expression, looking for your keys under the lamppost. Unfortunately, the DEA has really cracked down on opioid availability for chronic pain patients because they can regulate doctors and they can regulate patients, whereas most of the opioid abuse these days is with illegal fentanyl, and it's really hard to crack down on drug cartels. If it were easier, we would have done it already. I'm not involved in that, but you know what I mean. Okay, so I want to talk a little bit about the Dobbs case, and then I will open it up to discussion and questions. Actually, I'm going to go in a different order here. So in 1984, this is President Reagan, for those of you who were born in the 2000s. President Ronald Reagan made a speech about the rights of unborn children, I think he called them. And he referenced the pain of the unborn and the horrific pain that unborn children experience when they are being killed in an abortion. He made this speech shortly after seeing this film, The Silent Scream, which was released in 1983 and became a tremendously important source of focus within the pro-life movement. Silent Scream purported to show a fetus recoiling and showing aversive response during the process of an abortion. What does this film show? It is a series of stills from ultrasounds spliced together to look like an animation. In the apparent animation, it does appear that the fetus is trying to withdraw. This idea that a fetus experiences pain during an abortion procedure was rejected at the time by the medical community. And yet, hold on, I know I've got, yes, okay. And yet, in efforts to curtail access to abortion, many legislators began to take this concept of fetal pain and translate it into notification laws. The idea being that even if Roe required pre-viability abortion to be protected, the existence or the allegation of fetal pain could be used to pose a barrier for women seeking abortion. So here's an example of one of these patient pain notification laws from the early 2000s. They started being drafted by state legislatures in the 1990s. This went along with certain counseling requirements and other forms of process instituted to create friction in the abortion process. So this would be a disclosure that was required to be given to the patient by a provider performing an abortion. It reads, "There is substantial evidence that the process of being killed in an abortion will cause the unborn child pain, even though you may receive pain-reducing drug or drugs. Under this act, you have a right to know that there is evidence that the process of being killed in an abortion will cause your unborn child extreme pain." On this disclosure, I call it a disclosure, I'm not sure that's the right term. this statement was required to be given to every abortion patient, regardless of the stage of termination of the pregnancy or conception. So first, it's radically misleading. An early stage fetus, a blastocyst or a zygote, doesn't have nerve endings. There's nothing there to perceive pain. So giving this statement early, very early in pregnancy, is misdescriptive in every way. But you'll also notice the language, that it presumes that it is an unborn child that is already alive such that it can be killed. And it draws a derogatory contrast between the patient seeking the abortion and the treatment of the fetus or unborn child. That to the patient, you may get pain medication, but your child will experience extreme pain. So the role of this is less about, it seems to me to be less about notification of pain and more about trying to encourage the patient to make a different decision and not engage in this procedure. Because what kind of a person would cause an unborn child extreme pain? As you know, you've probably all heard the dictum in regard to animals. The question is not, can they reason, but can they suffer? Suffering is, as we say in criminal law, malum in se, evil in itself. And those who inflict suffering without good cause are generally considered unethical and morally abhorrent. And so this notification, I think, purports to be about the medical realities of the procedure, but is really about the normative stature of the unborn child. In the states that have these notification laws, or that had, now post-obs, they just generally have prohibitions. There is not, for example, a parallel notification law when you eat dinner in a restaurant or buy food in a supermarket. You have the right to know that although you may enjoy dinner, the animal on your plate experienced extreme suffering and pain in its rearing or in its slaughter. Now, that I do not mean to compare a human being to an animal, and there are very important differences between the context of a fetus and the context of an animal, but that's the point. It's the context difference. It's not pain itself doing the work. It's the different status or stature that we accord to a human life, and the question of whether it is a human life versus an animal life, whose suffering counts, whose pain counts. It is not pain itself. If all pain were a legitimate interest of the state, everybody or everything's pain would count equally. So we could similarly talk about the pain of the condemned. They are human, people subject to execution and people subject to solitary confinement. The Supreme Court has held that the Eighth Amendment does not require a painless death for those who are condemned, nor does it require that solitary confinement be without pain, but that some pain incident to punishment is consistent with the Eighth Amendment. So again, it's not that the state has an interest in preventing a certain amount or quantum of pain, it's whose pain. Is it a guilty person or an animal or somebody whom we find other, or is it the archetypal innocent? It's really the moral status and not the pain status that appears to be doing the lion's share of the work here. And this matures into the Dobbs decision. I'll give you a little bit about fetal development so that we're back with the science here. A fetus from relatively early on, from maybe around 12 weeks, is may experience nociception to the spinal cord. Maybe 16 weeks, excuse me. However, in order for the central processing of pain, we need some projections from the peripheral nervous system connecting to the spinal cord up into the thalamocortical area. And the very first thalamocortical projections appear in fetuses at approximately 24 weeks. So the current state of the science, and this is from a Nature 2022 article, and also from the amicus curiae, one of the amicus curiae briefs in the Dobb case, is that there is no connection there until about week 24. And that without these insular and thalamic inputs, a fetus will not be able to feel pain. Then, even if the fetus has the hardware for cortical processing of pain, the fetus is held in a sleep-like state by chemicals within the maternal environment, so that it is perhaps equivalent to an anesthetized patient who does have a functioning brain, but who is not in a feeling or conscious state. And the first evidence of sleep-wake cycles that might show anything like consciousness appear in the fetus at about week 30. So the science may change, but it currently appears that there is no evidence for pain perception prior to quickening. Evidence for nociception, yes. Pain perception, no. And again, that's why anesthesia before quickening can still be relevant, because nociception has physiological consequences. But the medical briefs submitted to the court take the position that in the first and second trimester, pain perception is not relevant. Yet, despite these briefs by the medical establishment and current consensus, the majority opinion in Dobbs writes, "A law regulating abortion, like other health and welfare laws, is entitled to a strong presumption of validity." That's true. The court, for those of you who are not lawyers here, the court is supposed to presume that the laws made by the federal legislature or by state legislatures are valid, and only strike them down if there is clear constitutional infirmity. So then the court says a law must be sustained if there is a rational basis on which the legislature could have thought that it would serve legitimate interests. Rational basis scrutiny is the lowest level of scrutiny. Protected categories get heightened scrutiny. These legitimate interests include respect for and preservation of prenatal life at all stages of development, the protection of maternal health and safety. This is my dog. Hello, Lucky. Good boy. Yeah, good boy. And the mitigation of fetal pain. So here, the court is announcing that the state has a legitimate interest in mitigating fetal pain, not in protecting unborn life or protecting potential human life. We could say potential human life is a legitimate state interest. And the court does say that, prenatal life at all stages. But beyond that, it includes the mitigation of fetal pain. Why? Because fetal pain, again, gives the fetus a status claim that it can suffer, and that suffering gives it a claim to, I think, increased humanity and to protection. There's a very, very long history in law and rhetoric of denying the reality of pain of those whom one would wish to treat instrumentally, and of crediting the reality of pain of those whom one seeks to bring into the fold of people or creatures like us, to humanize. So there's a terrible and longstanding discourse of denying the reality of pain among Africans and African Americans during slavery and segregation. There were claims around people of African descent not feeling pain or not feeling pain the way white people do. There's a history of medical experimentation by white American doctors on people of African descent on the ground that they didn't have a real pain experience. And abolitionists also frequently spoke in terms of the reality of pain and trying to humanize Black experience to other whites by talking about the reality of their pain. And there's a legacy of this today with the ongoing undertreatment of pain in African Americans. Women's pain, frequently not attended to, and animal pain. You know, when we don't want to think about what goes into our foods, producing food or fur coats, you know, then they don't feel pain like we do. But one of the most powerful tools in animal rights has been to talk about animal pain. And increasingly, we've seen neuroscience on the pain perception of fish to suggest that fish experience pain very similarly to what we would think of as pain experience, even though they don't have a prefrontal cortex. Now, I think interestingly, as a scientific matter, the work on pain perception in fish could be illuminating for pain perception in human fetuses. Maybe there is some non-cortical pain perception avenue that could provide for fetal pain perception. I am merely speculating here, prior to the development of thalamocortical tracts. And that would still raise the question, what significance does that have? Just as we cannot infer an ought from an is with pain perception in fish, nor can we in really any other domain. But at least knowing what exists is a good precursor. I mean, if the mitigation of fetal pain or animal pain is viewed as a compelling state interest, we might look to anesthesia rather than prohibition, or we might prohibit, or we might have a balance of rights. There is no necessary conclusion from the scientific fact to the normative discourse. And then I'll just finish with a brief comment on solitary confinement and to build a bridge from a scientific fact to a legal conclusion. And then I will thank you for your good and patient attention. So can we ever get from a scientific fact directly to a legal conclusion? In these most normative areas, probably not, but in certain areas, maybe. So in Eighth Amendment jurisprudence, which prohibits cruel and unusual punishment, the court has long established that maiming punishments are prohibited. So, and this goes back to the founders. So even if we're being constitutional originalists, we still have a prohibition on maiming. We cannot, the state cannot sentence somebody to have their fingers cut off or their face disfigured, for example. Nor can the conditions of confinement cause a person to be maimed. We couldn't put somebody in a box that's so small that they, after some years, experience a spinal deformity, for example. That would be a cruel and unusual punishment. So with solitary confinement, the court has resisted numerous challenges on the grounds of psychological or psychiatric maiming, but there is increasing evidence from neuroimaging that people subjected to lengthy terms in solitary confinement endure and exhibit negative neurological remodeling. If that brain difference is persistent in the way cutting off somebody's finger would be, that shows some healing, but the finger's not going to grow back, might that constitute a form of maiming? That would be a physiological alteration caused by a condition of confinement. So that would fit within jurisprudence. It's just a different kind of maiming. Similarly, with Social Security disability, we may be able to use brain imaging to produce evidence of a different kind of tissue damage that corresponds with excess pain, even if not in individual cases, on average, for certain kinds of conditions. So there, where the legal regime is well-defined and the physical criterion is well-defined, we can't maim, or we have to show tissue damage, or we have to show that a condition is real. We can bring in outstanding brain science to show, even if we can't prove it in an individual case, that on average, these kinds of differences occur or exist, where previously there has simply been skepticism or doubt or denial. But in domains where the discourse is primarily normative, how much can we torture somebody before it counts as torture? When should a pregnant person be allowed to terminate a pregnancy? Then pain takes on this much less physical, much more moral, ethical, totemic identity as a claim to who deserves what amount of rights and who is considered to be part of a community of experiencing sufferers like us. And there, neuroscience is important. I think putting good science before the court about fetal pain matters. The court didn't seem to attend to it, but at least they had it available to them. But there, I think we should continue to expect that pain discourse will continue to be more instrumental and have more to do with ethics and political predispositions than with a scientifically discernible true or false type of question. Thank you very much for your patience. I really appreciate it. It's rare for me to talk so long at a stretch. And I look forward to your questions.